not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years, and then she awarded him a contract where public money, either from Fulton County or the state of Georgia, ended up in his pockets. That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips. If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because the cash reimbursement theory, I'll talk about in a second, but if you do the math on what he actually paid for and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit. When the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for, and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. Cash theory only raises.
Before we get into that, let me ask you this. Let's say they couldn't have, let's say the theory wasn't even there that they had paid it back or that there'd been any exchange. Should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction? It's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that getting a pack of gum is just justification for disqualifying a district attorney. I think that's part of the issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts. So in that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly.
Right.
I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be the appellate courts are going to be deciding, well, is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money, it's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200 she's disqualified. I think if we go back to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes to the prosecution as a whole. I'm going to leave for, I'll resist the temptation to defend my wife, who I believe to be an excellent lawyer and a member of the bar for 20 years in good standing. But I will say this, Judge, you don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abadi stood up here in open court in front of national news and then the national public and called her a liar. I need to address that for 1 minute. There's text messages that are now part of the record, which now are substantive evidence for you to consider, prove everything that she put in that motion, everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public, cannot lie to the jury. And I think that's what he did. So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia about, and he just didn't do it.
How does the timing of the relationship impact financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to, every single question we asked Mr. Bradley was objected to, jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper, and if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about, and the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel, if you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yuri confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. The motion is accurate. And so also I do want to point out there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts. None of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what we know.
But does the lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade, and they developed, in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
Appreciate the court's time.
Good afternoon, Your Honor. I'm going to speak to what I would call a subset of forensic misconduct. And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you know, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place under the subset of forensic misconduct. Roman's counsel, this merchant, filed on January 8 her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that we, that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, D.A. Willis took it upon herself to go to a historic black church in Atlanta, having not responded at all to the motion of Ms. Merchant's client, Roman. And she made what we've now called the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech was. It was videoed. It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was black, without telling the public or the church members, or anyone for that matter, that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant. Ms. Willis took full opportunity to prejudice the defendants, and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion. Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion? That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So then what we get from the state is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraph 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021, and that's on page 7. So now we know that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade, Willis testify to the same thing under oath. Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor toward the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules. It says it's a violation of the Georgia Rules of Professional Conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness. A legitimate concern about the truthfulness, which equates to an appearance of impropriety. Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So, why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like, just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says, absolutely. Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then, unprompted, says this. And unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate emoji or whatever one would call it to say emoji, it was liked. And then Mr. Bradley say they met in the municipal court, CLE comments. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant said, that's what I figured. when he was married, and then this merchant says, we're now talking about a couple hours later, she texts and says, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong, other than magistrate court municipal. Now we have that, and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied. So what does Bradley do? Look, you were an assistant U.S. attorney. You know how this works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions. No recollection, couldn't remember, it was speculation. Anything he could possibly say that would cause Your Honor not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies, and the truth is in Defense Exhibit 26.
And so if we take that view, that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say that's the time he was telling the truth. In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than in just a assertion outright? Absolutely. Usually, if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective. They've got a full statement. We don't have that here.
Well, what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone else. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley, and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, the lead prosecutor, the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander. If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? the district attorney signs every indictment assigned to this courtroom.
No.
Does that mean she's off every case?
No, it would be when the,
If I found that she's untruthful, is that what you're kind of suggesting?
you don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registay and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth under oath, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving what I suggest to you is untruthful testimony based on what Yerty has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. And Your Honor was, fortunately, went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. That Yerty says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1 of 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Miss Willis was staying in Yerty's apartment. But more important is there are two occasions, and the state has not challenged those. There are two occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. Now, the state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, Supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerty had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35.
Okay.
But never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he did say he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No.
Okay.
It's not determined.
The overnight rate might raise some more concerns. Understood?
Yeah, it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestaff, because that is suggestive that they were not being honest to the court. So then, how much time have I used? Have I?
I'm letting them use the hook. So, suggestive. Again, raising issues I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with a preponderance standard, and it's our burden.
Yeah.
No question about that.
So does suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerty says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, so I can finish this up, if you find by a preponderance of the evidence that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gibbons can argue.
Before I let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says falls into that box?
No, I'm saying that
improper.
That forensic misconduct as a subset of that would include violations, ethical violations, which impact the ability of the defendants to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these two prosecutors, are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the two cases I mentioned. Ethical violations can give rise to disqualification, and I suggest we have that here.
All right, thank you, Mr. Sano.
Thank you.
Where's the shot clock when you need it?
Right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case, in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief, off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down, wrote out her speech, wrote out her plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case before it was supposed to be tried in this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So,
Now,
I mean, we have a pattern of public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying the defendant, a particular defendant, is guilty, and it even denied it, right? So, have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one response to an inquiry the court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school article, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for 2 reasons. And what she did reminds me of what the court in Estes v. Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls, the radio, or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that church in the face and say, there's been an allegation that I had a romantic relationship with Mr. Wade, and ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible for any lawyer, but particularly for a prosecutor. She chose to pull out the race card and the God card. That's what she did. And she wrote it out. She went on to deflect away from the allegations in the Wade motion, and she's saying, why, in her talk, public discussion with God, why are they only attacking one, in reference to Mr. Wade? And then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say, them, the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter, this is exactly what Hammonds v. State in our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Mr. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence, and is no evidence, of a personal romantic relationship with them in which he obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward. And she talks about a planned interviews time and time again with authors of a book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that those people calling me up and making those claims or those horrible racial slurs to me are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case when on May the 23rd, May of 2023, talking about, have you ever had sexual relations with a person during the course of the marriage or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not, on any occasions, he's entertained or been entertained by someone, a woman, a member of the opposite sex, in this case a woman, from the date of the marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that? He does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her. That's exact. And what these answers are absolutely reprehensible, that a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do? Miss Willis do? Miss Willis, on her financial report, on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade. All the trips, all the entertainment, all the 3 nights in the luxury suite in Aruba. All of that. None of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present, and the court gave me one back. the court has to fill out a form whether you got a Christmas present from anybody. You say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're false reports. And because they're false, what they had to do is they had to say, uh-oh, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important, and frankly, I do too. Because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct, and that is fraud on this court. When they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred prior to November 1, 2021, and the benefits that were there, and we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified and came up with their story. What's the only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and vacations and the cruises. I paid him back in cash. Show us your receipts. Where did you take cash out of the bank? Ever? Oh, I don't have any. Well, show us the deposits that he had. Well, never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, I gave him money, it evaporated, I don't know where it came from, and he doesn't know what he did with it. Just please trust us and believe us because it's our only way out of the trap that they set for themselves. These people, sadly, and I hate to say, as the court knows, I was a prosecutor for about 3.5 million years, it seems, in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need to go. Thank you.
Your Honor, I'm going to cover a few factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the state of Georgia, with the money that was paid to Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about. She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment, and how they conducted it. And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to, so that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurdy, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that they both, Wade and Willis, just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. I don't even think love-struck teenagers communicate that much. The November 29th and November 30th escapade, phone call from Ms. Willis, between Ms. Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Ms. Willis is staying, and he's there until roughly 4:55 a.m. None of the excuses, none of the explanations that Mr. Wade gave, going to the Porsche experience, going to dinner, going to the airport, none of that explains that. I'm pretty sure the Porsche experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night, right after he talked to Ms. Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Ms. Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that relationship began in 2019. Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment by Ms. Willis. You asked, in Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly $17,000 is enough. But Fulton County has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her explanation, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh. Oh, I just gave cash. I have no records for it. I have no source for it. The only thing that she could say that was a source for the money, because at times she said she was down to $500 to $1,000. The only explanation she had is, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary documentary evidence in. No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim. And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings. And we know that both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases. We know Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone, and I think that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case. So, Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Ms. Willis. The uncontroverted evidence shows that the money that he was spending on Ms. Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, they also got. There is a direct financial benefit that Ms. Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance but an actual conflict, then what Ms. Willis has done since then in this case creates an actual conflict. But again, as prior counsel has stated, we only need to show the appearance of a conflict. And we have done that by a preponderance of the evidence. In fact, I believe we've shown an actual conflict. But nonetheless, the result should be that Ms. Willis and her office should be disqualified from this case. We still have a few more minutes. I think Mr. Cromwell may have something to say. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor. Harry McDougall for Mr. Clark. I'm going to talk further about conflicts, and I'm going to assume the most difficult standard for us to meet, which is actual conflict. But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often, the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God. The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be weighed and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment, and you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which she was previously chastised by Judge McBurney. And that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has three obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There is no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false, and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church. I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. And the whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is no evidence that D.A. Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.
Your Honor, there's not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, can I reserve what I had, 5 minutes for
Sure,
rebuttal?
that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5, and we'll be back at 2:40-ish to hear from the state. Thank you.
There you have it.
Yeah. Right down.
Sir.
Just me. Just me. Good evening.
Sit. All right, we're back on the record. Stay ready.
Yes, Judge. I just been trying to get to where I can share my screen.
We need to add you as a host then. What's your profile name on the Zoom? Your screen name on the Zoom.
Adam Abadi.
All right, just making sure. Bear with us. Do you need it right away?
No, I can start without.
All right, floor is yours.
So good afternoon, Your Honor. I want to start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive admissions that his client has made based on the statements he made because of the representations she made to him. So, I know that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about romantic relationship, and she had absolutely no information as in regards to...
So, but wait, are you making an argument I should make inferences based... Now, these would be attorney-client privileges, or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is, that's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that, 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations. She said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court's going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share. Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication. And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard what the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and did it got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor. They were not able to provide any evidence as to, or to the contrary, of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights, have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights, were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied, and Ms. Willis as the District Attorney of Fulton County and Mr. Wade as the Special Prosecutor assigned to this case should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, determine. And here would be the state's contention, is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the District Attorney's Office. And looking at what
I think you're talking about, is this Ventura?
it's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that the standard is that it's a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced, that they argued here today and in their filings. And I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney is that you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that Your Honor that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Levy State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel has relied on in their briefs and here today, I would submit to the court the cites are misleading, many of them are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Yes. Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety can be the grounds of disqualification.
Well,
there are a number of these cases that seem to exclusively rely on the appearance of impropriety.
right.
So they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of propriety.
As it relates to a prosecutor or district attorney, yes. That is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court in reading those cases is that I found that they kind of fell into 5 categories. That some that didn't concern disqualification at all, some that determined or that were about, I call it divided loyalty, which is a conflict that arises from becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome, and then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction. And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today. The first, McIver v. State, has nothing to do or has nothing related to the disqualification of anyone.
And I think some of these are just relating to kind of aspiring for broad language about standards of prosecutors. So point taken there. But if there are more, all right, keep going.
So as it relates to one of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regency v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. So the next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
all right. Let me explore this one a little bit. Mm-hmm. So, in addition to you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about, or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome? Yes,
I would definitely agree that that would be an instance where disqualification would be necessary and appropriate, because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? Correct. But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because, as Your Honor just said, if there's an instance where an officer is lying, or where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless, because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure or the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance...
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required. In the series of cases, Young, that was referenced by defense counsel, as well as Nichols v. State, are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, that there's, they refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides. You've heard all about Whitworth. So So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be, that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured. So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what it has to be shown is an actual conflict. If it's speculation...
Is there any qualifier there, though, that's in a post-conviction context?
So
we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality. Was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought, if you have any reactions.
Well, I think what Your Honor said is pretty on point in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I guess I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pre-trial than post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and
but I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it's applied post-conviction versus pre-trial during pre-trial issues. And what I would say to the court is that...
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing...
Legal analysis, that is.
I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. What I can't do at the moment is point exactly to the page. At the end of the state's argument, I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about. The footnote where you references the appearance standard.
Yes.
All right.
Correct.
Okay.
Further, in Lambie State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor, or the status of the case being in post-conviction, based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State, 275 Georgia, Appeal 790, to the 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation is that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right, but that's a facted issue, whether it was split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public. And in a way that was to impugn her character as it relates to
one last shot for old time's sake.
That line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
They love me in Beverly Hills.
What do you think is
State v.
happening?
Sutherland,
We have got
190
one
Georgia
shot,
Appeals
and I
606,
need your help.
1989 case. And it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of. So I want to move into, I guess, the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here, sitting before the court, that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law. And what I would submit to the court is that Miss Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
I would agree with the court. It's not in evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But it's clear that what was represented as to why she would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify, that she shouldn't be compelled.
So then under that theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive arise?
So she was fighting so hard to avoid the if we're going down that road you propose, she was fighting to have not to come in here and testify at all, and then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it as is ultimately when she was forced to testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about whether she resigned or forced to leave, she was fired, she came out and said she was given the choice: you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which she wouldn't be officially fired when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would. But
if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that, well, I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high-profile nature, where everybody would be able to watch and learn what she has to say as it unfolds in the courtroom. And I'd further submit to the court there is reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal first-hand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice, and it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal first-hand knowledge, basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo. And this is, Your Honor,
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Let's do this.
Directly overheard. Which ones are we talking about?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hilgreen and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Just call me the Jersey James Bond.
in reference to your question, the unequivocal answer was yes.
I have to call the White House. You're not taking my phone.
When Your Honor is looking through the text messages, I would
more fight left in
submit to the court that the text messages don't even
one last shot.
say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify. As it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation, because it asks, do you think it started before she hired him? He says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court,
I have an army with me.
it's the source of his information is unclear. What I would say
is going to be a day you're going to remember for a long time.
As to a lot of things.
It's too risky.
But other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that conversation never occurred. That would be
Welcome to the
state's
Women's
contention.
Army Corps.
We have
And
the
how do we know
most
that?
to
We know
prove.
that because
Now is where
that
you
conversation
show the proof.
was not confronted, or Mr. Wade was not confronted with that conversation. And that
Most remarkable shade
is
of
evidence
I
circumstantially, and I'd even say direct, as to that conversation non-existent.
might say
because
something like that if you were a suitor.
based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, a government, official government document. He further testified that not only did it wasn't that just Ms. Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Ms. Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Ms. Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South Fulton home that is owned by Ms. Willis. He made clear that he lived in that home with Ms. Willis and Ms. Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Ms. Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Ms. Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times. He said, in reference to the questions by defense counsel that were in a, and I'm just going to be straight up with the court, they were trying to make Ms. Willis a liar, what is how I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but failed. Would be how the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office, and he talked about how he kept cash in his home and why Ms. Willis kept cash in his home. And what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. So there was I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. He further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it, did it follow her, where she laid her head, and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence was it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it'd be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead prosecutor.
At that time, as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor, lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gay Banks, in addition to Mr. Wade. If she has this grand plan scheme in order to profit off of the prosecution of this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason. Your Honor. Other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court, I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
Just trying to make sure we know exactly what is in the evidence and is not, but regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continued to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor, reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination that Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did in fact pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court. You heard about...
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now, I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely. But we use them with an expert. And they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about them.
No. Focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that? So,
what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer-reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates, I believe it's September 10th and 11th and November 29th and 30th, the affidavit that is used to say that Mr. Wade remains at Ms. Willis's, or in the area of Hateville, because again, during the hearing, the address for the Yurdy condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now, I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere, how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't. So what's interesting is that the records that were provided they start in January of 2021 and they go, I believe it's to November 30th, I think is what of 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdy, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home. But they're dating. But they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so. But he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that was not a lie.
Solutions for
That
every
he had never
industry.
been to that home.
Call
and
clickgranger.com
it's
or
more
just
than
stop
suspect
by.
if you've been in a relationship
Granger,
as they
for the
claim
ones who get it done.
for all this time, but never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live, again, at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How do
she's not
you
living.
reconcile that with his testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
Would those line up to 23 times?
Get out!
You know,
well,
I think there are too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in, and clearly that is the case because Ms. Willis didn't live in that area.
I gotta get out, bro.
So again, it's further corroboration as to what Mr. Wade indicated to the court. And when, I guess after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records, it's not SMS or text messages, it's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention, as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you are close with, and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I've been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had and still have, that we talk 30 times a day. So that doesn't mean we're in a relationship. So the assertion that the number of times that Ms. Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety in her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposely leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from an HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. But what was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone to gone with all 39, there's based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged from the prosecution of this case? It doesn't line up, it doesn't make sense, and it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large-scale cases like this one, and much larger. And they also have, there's a lot of high-profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Ms. Willis was living the lifestyle of the rich and the famous is a joke, an absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what has to be shown is that the statements that were made by Ms. Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. We have none of those statements. There's been no evidence. Nothing has been provided to Your Honor as it relates to Ms. Willis' specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate in the previous year that she was serving as a district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis, and it involved a statement that the words fake electors were said by Ms. Willis, and he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne, two other political officials, therefore making her comments not even close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as two unrelated, in this case public officials, criticized the job that she was doing. And I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain, was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media, simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selected prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with, and how the state started the argument, is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. An actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all of those reasons, Your Honor, we would respectfully request to deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
All right, thank you, Mr. Vaughn.
Your Honor, I think we have 5 minutes and 44 seconds.
That's what it says. Mr. Cromwell.
Conceding the,
Oh, you, okay, handing it over. Understood. Mr. Sadow, all yours.
Thank you. I'm going to do rebuttal, specific rebuttal. One, state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. And Wade's counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take, as disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand. But as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. Second, let's use a little common sense here. Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct, why is that?
I'm sorry, say that.
Here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever. The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship. Ever. They concealed it from all parties. From Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was best friend at that time with Miss Willis, and Bradley was the partner of Wade. Now, the only way that Bradley can walk away from the, I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do. And
All right. Thank you, Mr. Sano. There it is. All right. Thank you, everybody. I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make, and those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, council can reach out, and we'll have an order posted on the docket. Thank you all. We're off the record. Thank you, Mr.
You could skip this ad, but don't skip the part that can help you get the job done. At Grainger, we're here for you with supplies and solutions for every industry. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
Have you heard? Sling TV offers the news you love for less. Wait, you look and sound just like me. Actually, I am you. Because I'm the same news programs on Sling for less. You mean you're me, but for less money? A lot less. I'm all your favorite news programs and more on Sling, starting at just $40 a month. Everything great about me, but for less money? Which makes me greater, don't you think? It's the same news for less, starting at $40 a month. Sling.
Give that a shot.
Your Honor. Okay. And again, I know that this argument has already been raised before Your Honor at the October hearing. And in reading the October hearing, one of the things that kind of came to mind is, and I know that this seems like it's fairly obvious, but the scope of RICO does not apply to the allegations in the indictment. And I want to start off with something that I think is fairly fundamental, but I think it kind of got lost at the last hearing, and that is that 1614-2 is a law. It is the law of this state. It was passed by both houses of the General Assembly. It was signed into law by the governor, and it is the law of this state. It is not a resolution. It is not a guideline. It is not a suggestion. It is something that the state has to deal with. And in particular, what the state has to deal with is the fact that 1614-2 scope limitation that is contained in subparagraph B cannot be ignored. Justice Peterson in the Harrison versus McAfee case explicitly said that unlike captions, codified preambles are part of the act and are appropriate to be read in pari materia with the rest of the act. And I cite numerous cases on this slide where the Court of Appeals and the Supreme Court have repeatedly said that when you enact something in a preamble or in a statement of intent, that has to be given meaning, and it has to be read with the rest of the statute. The courts have also said, and these are just cases from 2021 to 2023, and I think there's about 25 of them from the Supreme Court and the Court of Appeals. They say that they will not read out of a statute language that the General Assembly has decided to put in there. They are not going to ignore language that the General Assembly has put in there as mere surplusage. So there is going to have to be, the preambles mean something, it is the law, and we are going to have to deal with the language that is in there. Well, when we look at the law and we look at what's in 1614-2, and I'm going to go through several canons of construction. The first canon of construction is that we start with the plain language of the statute. And when the plain language of the statute presents an answer to the question, we can stop there. Here, what does the plain language of 1614-2b say? It says that it is not the intent of the General Assembly that isolated incidents of misdemeanor conduct or acts of civil disobedience be prosecuted under the chapter. Very, very clear. It is the intent of the General Assembly, however, that the chapter shall apply to an interrelated pattern of criminal activity motivated by or the effect of which is pecuniary gain or economic or physical threat or injury, period. At the October hearing, the state didn't deal with and explain what the words pecuniary gain, economic or physical threat or injury mean, and how those are imported to the rest of the statute. It did not deal with the plain language of the statute that it doesn't apply to acts of civil disobedience, and it has to. We have to deal with that language. And here, the General Assembly has expressly said that it is not going to apply, RICO Act doesn't apply at all to acts of civil disobedience. And we have, in our prior briefing with regard to the First Amendment, we have shown and gone through in detail in the indictment every single allegation, every single thing that the state is saying was done wrong are all statements, political statements that are made around the 2022 presidential election and the vote counting thereof. All of those fall within the category of civil disobedience if that is read appropriately. More importantly,
Where do you find the definition of civil disobedience? It's not in the RICO statute itself, right?
no, it's not in the RICO statute. I think that it's,
So how should we define that?
I think it should be defined as a political statement that is in opposition to some stated position of the government. And here you have a stated position of the government that, Joe Biden won the election, that the vote counting was correct, all of those things. And the people that are indicted here, and the state expressly says it in their introduction, we are going after them because they disagree. That's what they say. And so I think that civil disobedience can be read for that purpose. Moreover, when you look at what does the statute apply to, the statute only applies to economic, fiscal, or bodily harm. That's what it says. It's
So what do we do with the last sentence? That's the one.
What's the last sentence?
Liberally construed, and the
Okay.
focus is on the operative provisions.
I was going to get to that, but I'll get to it right now.
I think that we wouldn't even be having this conversation but for that last
All right,
sentence.
this is an easy one. Hold on one second. Hold on one second. I apologize. Gotta get to my right slide. Okay, here it is. All right. The state, I kind of feel like it's the Princess Bride, where I don't think that the words that they're using mean what they think they mean. Penal statutes in Georgia, and RICO is in part a penal statute, are always strictly construed against the state. That is the rule at common law, and it is the rule in case law right now. It is strictly construed against the state and liberally applied against the accused. And I've got a couple case sites there. Now, your question, Judge, OCGA 1614-2B says, this chapter shall be liberally construed to affect the remedial purposes embodied in its operative provision. Okay. There are two components of the Georgia RICO Act. There is a criminal component to it, and there is a civil component to it. What does remedial purposes aim at? Remedial purposes, and I took remedies in college and law school, is aimed at a civil aspect of the case. And Georgia courts applying this statute have said that the remedial purposes of the Georgia RICO Act, and this is in the case that I have cited here, the tabletop case, is to provide compensation to private persons injured or aggrieved by reason of any RICO violation. The remedial purposes of the statute apply to the civil part of the statute. It is also well established in Georgia law since at least, 1921, that the remedial purposes of a statute relate only to civil remedies, and that the liberal construction direction in 1614-2B applies only to the civil remedies. So as to the civil components, the purpose being to compensate persons harmed under RICO, liberally apply. When it is a criminal, as it is here, sanction, penal sanctions, you go to strictly construed. That's what the case law says. And in fact, in the case that we have cited here, the Shearman case, it says the same statute, and that's my bracket, like RICO, may partake of each of these separate elements to such an extent as will render it penal in one part and remedial in the other. And I didn't my presentation's already clogged up with a lot of words. It's fairly
I've already
busy.
gotten you off track, but let me keep doing that, just to
Yeah.
keep you on your toes here. So have you ever seen a case applying RICO where they've made this distinction between civil and criminal?
It's right here, tabletop. And the other thing that I will say is, and that's the plain reading. And I don't go into all of the other cases. There are cases in 2023, I think I just cited one in here, that talk about the application and the definitions of remedial and penal. There are two different things. Remedial is civil, penal is criminal. And if we dig into it, and if Your Honor wants a very long brief with a ton of case citations, I can do it. But that is what it means. And the other thing that I will say is, even if remedial purposes were to apply here, remedial purposes don't mean that you ignore the plain language of the statute. It doesn't mean that just because if you had a remedial purpose, even for the purposes of civil liability, that you would go beyond the plain language of the statute, which says that this applies to financial harm, economic harm, or physical injury. And I think physical can either be bodily injury or injury to property, probably. But that is it. And if you look, Your Honor, at that is explicitly what the General Assembly says, and I think we can stop and end with the plain language of the statute. But what we can also see is that the RICO limitations are relatively unique. So when you look at the federal RICO statutes, they don't have those same limitations that Georgia puts in there. And we've done some research, and I think that really no other states do. North Carolina comes the closest. And in North Carolina, their statute, General Statute 75D2C, provides for, it is actually more like our old statute pre-1997. But the North Carolina courts interpreting that scope limitation have said that the plain language of the statute, coupled with legislative intent, clearly indicates that the scope of RICO is limited to cases where pecuniary gain is derived from organized unlawful activity prohibited under the statute. So a North Carolina statute dealing with the same type of statute that we have here has imposed those types of limitations to limit the scope of RICO. And if the plain language wasn't enough, we look at what else did the General Assembly do with RICO. I went through every single RICO activity that's listed. And every single racketeering activity that's in 1614.35A has to deal with either economic or fiscal harm, fiscal being money, obviously, physical harm, or both. And that slide shows where every single one of those predicate acts are dealing with that. What does that tell you? That tells you that the General Assembly really meant what it said in the preamble, and that it's going to apply to these types of things. So when we're reading the rest of the statute, we're saying, okay, that makes sense. That makes sense. The General Assembly has said it in the introduction, and then they've proved it out in the racketeering activities that they've put there, that those are the primary directions of those racketeering activities.
So when the state comes back and says, even if we accept that, one, it doesn't have to be explicitly alleged. You can just bring this up at a directed verdict 6 months later. Or two, we're going to be able to show that in the facts of this case.
I don't think that that's right. We are here on a demur. And in a demur, the state has to state in its indictment exactly what are all the elements, what are the facts here, and that the statute applies. And they haven't been able to do this. I also ran a search in the indictment. What do I not see anywhere in the indictment? There is not one allegation of harm to a body or to property. Not one. There is not one. If you type in the word money, if you type in the word fiscal, if you type in the word economic, it's not in there. And it's not in there because the state's entire indictment is explicitly premised. Again, go back to their introduction, go back to their definitions of enterprise. It is explicitly premised upon their disagreement with the political speech of these people and the political activities that they undertook, none of which allege any type of economic or physical harm. At the last hearing in October, the state stood up and said, well, maybe Donald Trump got money from being a president. No, maybe Ruby Freeman was physically threatened. And my response to that is, when we look at the case law, indictments don't get helped by argument or briefing. Indictments stand or fall on what is alleged in the indictment. And the things that were argued at that last hearing, and
They're not in there, but why is this, what's your authority that says this is an essential element that has to be alleged?
I don't think that it's an essential element, but just like statutes of limitation, jurisdiction, other types of things, the limitations of the statute are on its face in there. And the state is going to have to say in its indictment for RICO to apply that this is economic, fiscal, or bodily injury. It's got to plead that, and it pled nowhere in there. And the state is simply saying, listen, I want you, judge, I want the courts to just don't believe your lying eyes, cover up what it says in the statute, don't look at what we've specifically pled in the indictment, and maybe coulda, shoulda, woulda down the road, we can prove something. That's not what their burden is in an indictment. Their burden is to state all of the material facts that show the complaint, is state all of the elements, and if they can't show that this act applies, and they haven't shown that this act applies, then it is due to be dismissed. And I think that this is important because not only are there, do the plain language and everything else that I've just told you support that argument, but you then get to look at the statutory history. Georgia courts have repeatedly said that we are going to look at statutory history. Statutory history is not legislative history. Statutory history is when we look at the changes in the statute, and when we look at the changes in the statute, we see that the General Assembly has made a considered choice to do something. And what do we know that happened in 1997? In 1997, there was a case, that Savage case, that looked like it was competing with a couple of other courts of appeals cases. And the General Assembly came in and said, listen, we want to both expand and constrict what RICO is looking at. We are going to expand it by adding economic or physical threat. That's going to be some additional words that we're going to put in there. So they expand the scope to that. But then in order to get it through, just like any legislative process, you got to get a lot of people to agree. They said, we want to make sure RICO doesn't go too far. And so we're going to exclude civil disobedience. Had the General Assembly wanted to come in and said, listen, if you have a, I don't think they could do it constitutionally, but if they came in and said, listen, if you've got political speech, that falls under RICO. If you've got some other argument, the violation of Title 21, the election code, that falls under RICO. What did the General Assembly do? It didn't do either of those things because it didn't mean it. And here, you're not even dealing with a statute where you've got this, and then a catch-all phrase, or including but not limited to. This is just clear on its face, and it says it's these three things, that's it. And we know that the General Assembly in 1997 went through again. This is why I harp on the fact that this is the law, is the General Assembly felt it was necessary to go in, both chambers, go through the process, go through committee hearings, get the governor to sign it, to make it a law of this state that this is what RICO is limited to, and the state doesn't even do that here. Moreover, when we're looking at these things, if the plain language and the statutory history are not enough, we apply the canon of constitutional doubt. And the canon of constitutional doubt will say, and I don't want to take up, I see you looking at the clock, I don't want to take up Ms. Clark Palmer's time, but it says that if possible, that we can read the statute in a way that it's unconstitutional, then we really ought to read it a different way. I'm not going to go through all our First Amendment arguments, but clearly there is a problem here that if you read the statute in the way that the state wants, you will render it unconstitutional, and under the canons of constitutional doubt, it ought to be read the way that I'm saying. We've already gone through the strict construction and the limitations. We also look at legislative history. Georgia courts don't always look at this. Sometimes they do, sometimes they don't. We've cited the Gable case, and it talks about what Mike Hobbs had to say, what Senator Clay had to say, what two other people in the General Assembly had to say, and I'm pretty sure I know what Mike Bowers would say. And the only thing that's contrary to that is a meeting at a barbecue restaurant. If you take a look at what the legislative history is, then the legislative history is going to say that RICO only applies to what I'm saying. So you look at then the plain language, the doctrine of constitutional doubt, the statutory history, the application of strict construction to penal statutes, and then the available legislative history. All five of those things are in our benefit. And because all five of those things are in our benefit, then the RICO statute needs to be read in the manner in which I have suggested. And again, the only thing that the state has said, and I read very carefully the October hearing, is, well, just ignore it. And you can't ignore it. And Your Honor, because I'm running over, I'm going to stop. And I may get up and respond to Mr. Floyd if you'll allow me, but I'm going to allow Ms. Clark Palmer to present her issues.
Do you mind? I don't have a strong opinion. Okay. If it's acceptable to counsel, Your Honor, I just soon respond to Mr. Nullis so that we don't mush everything together, as it were.
Floor yours, Ms. Floyd.
Thank you, Your Honor. Thank you. Okay, Your Honor, 1614-2, the provision that launched 1,000 demurs. The state does not, and has never said, ignore 1614-2 like it doesn't exist. That's just not true. Okay? 1614-2 exists. The question is, what, if anything, does it do in the context of this case? And the effort here is to turn it into a pleading requirement. That's the whole name of the game. It's not a pleading requirement. The Georgia courts have held over and over again it doesn't create a pleading requirement. Those rulings are binding. Cotton Inc., Shearson, Roe, those are decisions of the Court of Appeals and of the Supreme Court, and they say you do not have to plead in accordance with this. You don't have to plead affirmatively that organized crime is involved. You don't have to plead affirmatively pecuniary gain, economic or physical threat or injury, etc. The corollary to that is you don't have to plead the negative either, which is it's not civil disobedience, etc. That's where we sit right now. Okay? That's the law. We're not starting on a blank slate here, right? And my friend, Mr. Nulowitz, he's emphasized certain things, but certain things didn't really get mentioned along the way. The United States Supreme Court, part of the argument is that you have to interpret it as he would have it to save the constitutionality of the statute. Okay? No, you don't. The United States Supreme Court looked at that question in Now versus Scheidler and said, no, there is no requirement of an economic harm or injury. That's not needed to, quote unquote, save the statute. Right? Nor is there anything about the application of this statute in this case in a First Amendment circumstance that is required to, quote unquote, save the statute. Let me stick to the economic or pecuniary gain or economic harm, etc. First of all, there's no indication that that's a proof burden on the state. But if it were a proof burden, it is not an allegation burden. And much of the game of demurs, as Your Honor has seen, is always let's turn the probata into the allegata. If it's something the state would have to prove at trial, then it must be alleged. The law is absolutely to the contrary. That is not the case. We do not have to plead all our evidence. We don't have to plead in anticipation of affirmative defenses. And these are affirmative defenses. They're not pleading requirements. No Georgia case says these are pleading requirements. Right? The General Assembly hasn't even said they're affirmative defenses, and the General Assembly certainly knows how to do that. There is statute provision after provision after provision in the criminal code where the General Assembly says this is an affirmative defense. They did not do that here. They did not take 1614.4 and say, state, you must prove economic or physical harm or injury, etc. You must prove not civil disobedience. That's not in there.
So then what is the ultimate effect of that sentence of expressing the intent of the Assembly? Is it just a suggestion of a hope?
They are generally characterized as precatory words in statutory analysis, yes. And they may provide, in a close question, some guidance to Your Honor. I mean, that this is what we were thinking. This is why we did what we did. But it's utterly illusory to think that this covers all the circumstances of RICO. And this is both the blessing and the curse of provisions like this. There is a somewhat similar provision in the Organized Crime Control Act of 1970. RICO is Title IX, if I recall correctly, of that provision. And a great deal of ink has been spilled going through, it's often referred to as ACCA, the preamble to ACCA, and the same arguments, species, the siblings of these arguments. You must prove an organized crime nexus, rejected, okay? You must prove a racketeering injury because that's what Congress wanted, rejected, right? You must prove, et cetera, et cetera. I mean, the history of the United States Supreme Court decisions on RICO is defendants coming in and pointing to legislative history or the preamble and saying, here's a thing that also has to be in here, because otherwise it, quote unquote, wouldn't make sense, or that's what Congress intended. And the Supreme Court has said no, and they've always said no on the basis that we look at the operative provision. It's not there. You know, I mean, when federal RICO was passed, there was endless discussion of organized crime and it's invading the United States economy, et cetera, okay? And when defendants said, you've got to plead this, state, you've got to prove it, civil plaintiffs, you have to prove it, the court said no, because it's not in the definition of the offense, right?
And so the last sentence of the what counsel was saying is that there's this division between criminal and civil.
Yes, no, there's not. And the case he cites doesn't say that, okay? And Georgia has never done that. And the problem is, what he's saying is, as a consequence of his interpretation, it's completely untenable, because it means 1614.4 A, B, and C mean one thing in a civil case and another thing in a criminal case. That makes no sense.
Why is that untenable?
Really, because you've got to figure out what each word means, right?
So he points to remedial. I guess they didn't have to include the word remedial. They could have just said effectuate the purposes.
Yes, but it's operative provisions. 1614.4 is an operative provision. The application of those operative provisions in both civil and criminal cases do have remedial impacts. For example, is stopped from denying the facts of impact on remedial provisions down the road. And that's expressly in the statute. General Assembly knew exactly how to do that when they wanted to. But in contrast to the statements of intent, in looking at this, in the first sentence, the General Assembly declares its intent. Second sentence, its intent, not in its intent. Third sentence, is its intent. Last sentence, shall be construed. Not, it's our intent, our general sense, our suggestion, our recommendation, or please think about this, courts and prosecutors. It is shall, mandatory language. Only time shall is used in the provision. And that is the language that you looked at in your earlier ruling of October 17th. That is the language that the Court of Appeals has looked at as well. Pecuniary gain. The argument was made to you that after an exhaustive look through the statute, that every violation defined as racketeering activity either causes economic, physical, or a bodily harm. That is manifestly not the case. Perjury, false statements, tampering with evidence, obstruction, forgery, destruction of evidence are all violations. None of them necessarily cause economic or physical harm. None of them, all of them are defined as acts of racketeering activity. Those are just the examples I could come up with off the top of my head. There's probably many more than twice that. It is simply not an accurate characterization of the statute. That is not how this statute was built. It was built long before 1997 when this was done. And there is no such structure. That's what they tried in Now versus Scheidler. And that actually goes back to a Second Circuit case called Ivich and another one called Bagarich, both of which imposed an economic motive requirement. Those were rejected by the United States Supreme Court. Why? They said, we're not having a seance here about legislative intent. We're looking at the operative provisions, and it's not in there. Okay? And if this was a limitation, if this was a requirement, absolute requirement, as Mr. Nullis would have it, it would be in 1614-4A, and it is not. The presumption is here that somehow the state has to allege in the indictment exactly every economic impact, exactly every harm, exactly every bit of anxiety. Nothing says that. Nothing says that. Has the state alleged a circumstance where it could not do so? Has it precluded itself from doing that? Absolutely not. Nowhere do we say there's no economic harm, pecuniary injury, etc. Nowhere do we say this is civil disobedience and exercise of First Amendment. No, that's a characterization of the evidence that they say they will put forth at trial. That is not a pleading contest. We are not in the 17th century here. Economic harm. We allege data was stolen. We allege equipment was intruded into. That's economic harm. All right? That data has value. That data is defined by the relevant statute as property. Economic gain. Well, the name of the game, as I pointed out when we had earlier argument, was to make Mr. Trump president even though he lost the election. That carries with it a lot of things. A very large salary, benefits, retirement benefits that are very substantial, the most prestigious residence in the world, and the most prestigious transportation in the world. In anyone's mind, that is economic gain.
And is the trio of cases around Sevchek in the 90s, is that really the last time this ever appeared in a Georgia case?
Cotton Inc. is a little more recent. Cotton Inc. is in the 2000s.
It's been 20-something years since anyone's tried this?
It's been a long time. They've pretty much given up on it. Perhaps the motivation here is more powerful. I don't know. No, this has been essentially regarded as a discredited argument. Let me turn to civil disobedience for a moment. Mr. Cheeley tries to recharacterize things like his false statements regarding vote counting as an act of civil disobedience, right? First, again, as we've said before, 1614.2 doesn't modify the essential elements of a violation. It doesn't create them. But second, there is no basis to conclude that his conduct, for this court to determine as a matter of law, that his conduct was civil disobedience. And you've been offered none. They've just said it. It's just Dipsy-Dixon. Okay? So that term, as you pointed out, Your Honor, is not defined by the statute. It's not defined by any other provision of RICO or any other Georgia statute. Pretty much leaves us looking to common parlance. Where does that take us? Well, the New Oxford American Dictionary calls it the refusal to comply with certain laws or to pay taxes and fines as a peaceful form of political protest, right? Other dictionaries use essentially the same definition. It is a fundamental concept of civil disobedience that the person engaging in the disobedient conduct acknowledge what they are doing, acknowledge they are violating the law. That's actually the point. And that they accept punishment for it. I looked at the Encyclopedia Britannica article on this. The civil disobedient, finding legitimate avenues of change blocked or non-existent, feels obligated by a higher extra-legal principle to break some specific law. Is because acts associated with civil disobedience are considered crimes, however, and known by actor and public alike to be punishable, that such acts serve as a protest. By submitting to punishment, the civil disobedient hopes to set a moral example that will provoke the majority or government into effecting meaningful political, social, or economic change. Chile did no such thing. We don't allege he did it. He can't introduce facts controverting our allegations in connection with a demur because it becomes a speaking demur and the court has to deny it. But Chile, one thing we know, Chile denies violating any law. Chile is not a civil disobedient. There's no reasonable interpretation of the term civil disobedience that could include soliciting public officers to violate their oaths, not the oath of the disobedient, somebody else, asking somebody else to commit a crime, making a false statement or writing, committing perjury. Okay? Those are acts that Chile is charged with. Under no definition is that civil disobedience. And simply getting up and saying, I asked some questions about an election, that's not civil disobedience. Okay? And he says, he invokes the First Amendment again, but that's not what they're charged with. That's the problem. They're trying, they don't get to modify our indictment. They don't get to edit it, rewrite it, etc. They can go to trial and present facts if it's a legitimate defense, but that's it. Solicitation of somebody to violate their oath is not civil disobedience. Lying by making a false statement is not civil disobedience. Perjury is not civil disobedience. These things are deceptive. These things are immoral. It is not calling forth a higher moral principle. It is being sneaky and dishonest. As a co-conspirator, Chile is also responsible for the acts of his co-conspirators, all of them. Impersonating a public officer, forgery, filing false documents, influencing witnesses, computer theft, computer trespass, computer invasion of privacy, conspiracy to defraud the state, to deceive the state, acts involving theft. Under no reasonable interpretation is any of that civil disobedience. It doesn't become so simply because the defense would like to don a particular mantle. Most importantly, none of these defendants admit any of the crimes they committed, which puts them directly at odds with the fundamental premise of civil disobedience. As I said before, it's interesting. This has not been asserted as an affirmative defense. And I think that's quite conscious because the defendants know then they have to go to trial and have the burden of coming forward with evidence on that. Instead, they're trying to turn it into a sort of super affirmative defense by elevating it to a point that lets you, in essence, push an override button on the indictment. But again, and I mentioned this briefly at the beginning, when the General Assembly wants to create an affirmative defense, they know exactly how to do it. And I'll give you just a few examples. Article 3 of Title 16 consists entirely of affirmative defenses. 16.810 creates the claim of right as an affirmative defense to theft offenses. 16.620 and 21 create affirmative defenses to bigamy. And every one of these says it shall be an affirmative defense. False or fraudulent identification, 16.94. 16.11.127, carrying a weapon in an unauthorized location. 16.12.141, abortion. 16.13.32.4, transaction in controlled substances or marijuana within 1,000 feet of school property. In every one of those instances, the General Assembly thought under some limited circumstances there should be an out. And they said what they meant, and they put it in the statute, and they said, you know, defendant, if you can establish this, you are not guilty. They did not do that here. I'm happy to answer any questions. I think I had one other point. The tabletop case that was cited as being a RICO case, it's not. That's, you know, when we've talked about this before, there are statutes out there. There's one in the Gang Act, a provision in the Gang Act which is very similar to RICO. The General Assembly didn't include it here. Basically says the court can examine whether the charge is consistent with legislative purpose. New York has a judicial override provision in its Organized Crime Control Act that specifically allows a judge to dismiss a case if they believe the prosecution is not consistent with the purpose of the statute. The General Assembly did not do that. They did not, in essence, cross the wires between the branches. These devices exist, but they are not here. They are not in this circumstance. And the defendants have not given you a way to logically apply the provisions as they would interpret them, which are manifestly incorrect, let me be correct, to this case. What they want you to do is just make a sweeping statement that the defendants call certain conduct civil disobedience, therefore it is, therefore pleading requirement that's utterly undefined and utterly uncodified wipes out the indictment. That makes no sense. And quote-unquote civil disobedience would now suddenly become a defense to almost every RICO case because almost everybody's going to say, I did it for a higher moral purpose. Normally, that is no defense at all. And the General Assembly knows how to enact an out like that, and they did not do that. And in fact, their final admonition is that this provision shall be liberally interpreted. The argument that is being made is one that's, the two arguments that are being made are ones that are intended not to liberally interpret to achieve remedial purposes, but to gut the statute. No Georgia court has done that. No Georgia court has suggested that that's appropriate. And the decisions that exist interpreting this provision do not leave that leeway. There is simply not room for that approach. They have gone exactly the opposite direction. And they were right in doing so. What they did was entirely consistent with what the United States Supreme Court has done with RICO. The find a requirement game That is, find a requirement that's not in the operative provisions, apply it, and use that to dismiss a case is something the U.S. Supreme Court has rejected over and over and over again. And it's important because it's a game that has no end once it begins. And it, in essence, amounts to rewriting the statute as the General Assembly enacted it. Because the guts of this statute are 1614.4. That's what tells us what a violation is and what a violation isn't. They want to change it. They want to add to it. They want to really add words to that provision. And not just words that would create a proof requirement, but words that create a pleading requirement. And so we now get into an endless game where the state would have to anticipate every possible defense and plead in anticipation of it, and according to the defendants, plead every fact it has in anticipation of that defense. There is no Georgia law that does that, and now is not the time to start. Thank you.
Thank you, Mr. Floyd. Sure.
Just very quickly, the only thing that we are arguing here is in the four corners of the indictment. It doesn't state a RICO claim. It's not an affirmative defense. It's not anything else. We are within the four corners of that indictment, and do they or do they not? I've heard a lot of references to the United States Supreme Court. The federal RICO statute doesn't look like the Georgia RICO statute. The Georgia RICO statute is unique, and the General Assembly here has explicitly said what it is limited to. At no point in time in Mr. Floyd's remarks did I hear what does it mean to limit it to economic, fiscal, or bodily harm, because they don't have an answer. The other thing that he said, there seems to be some type of issue, well, this hasn't come up in 20 years. No, it has not. Why? Because as they admitted in the last time that we were up here, this is a unique case. Prosecutors understand what RICO means. And they have taken the RICO statute, they have morphed it and twisted it and cajoled it into something that the General Assembly expressly said it does not apply to. And why hadn't we seen this come up in 20 years? Because nobody else has dared to do it. With regard to the three cases that Mr. Floyd referenced, Cotton versus Fildan, he says that there's no requirement in the statute to allege a nexus between organized crime and the economy is of no consequence. That's what Cotton said. What do we know from Ms. Clark Palmer's Kimbrough case? Yeah, you do. The Georgia Supreme Court has expressly said that you do have to do these things. Cotton, a civil case, Rehal, a civil case, and when you look at them in those cases, all of them are alleging economic harm, which was the statute at the time. The statute was changed even after Cotton. Cotton was dealing with the 1996 statute. The General Assembly changed it in 1997. And so at no point in time, those cases don't apply here. And when I'm listening to the argument by the state, they seem to think RICO's got this talismanic magic that it covers everything, and that when they say it, they can circle kick a defendant. No. You have specific limitations in the statute as to what it applies to. You've got enterprise. You've got all of these different things. You've got to have a listed predicate act, and it's got to be economic, fiscal, or physical harm. That's what the General Assembly said, and they've said it over and over again, and Justice Peterson said it, and the cases that I cite to you say it, that you've got to give that some effect, and the state has failed to do that at all here. With regard to the other numerous references to other courts, our courts have said that it does have meaning. Our statute is unique in the nation. And with regard to how the Supreme Court has taken issues and whether or not it has applied RICO to issues of protected constitutional First Amendment activity, I got a whole slide with lots of different cases, but it starts off with Alexander versus the United States, 509 U.S. 544, 555, 1993. The RICO statute does not criminalize constitutionally protected speech. And it can't. And what do the words, we get off on, it's some type of throw in civil disobedience where I've got to be willing to go to jail. What the common definition is under Merriam-Webster, refusal to obey government demands or commands, to disagree with the government, forcing concessions of the government. When the statute was applied and you look at the law review articles and other things that surround it at the time of the statute, they're trying to make sure that abortion protesters, environmental protesters, people that are getting up and saying, listen, I disagree with you, that they're not going to jail. And in the 20 years, 25 years since this statute has been passed, that has not been applied in one case, one time, except for here. And why hasn't it? Because the statute doesn't apply. And I've given you 5 reasons. Plain language, statutory history, strict construction. We didn't hear any differentiation, and you've got the cases and you've got the discussions about penal versus liberal, and on that again, even liberally applied. You've got to give effect to the plain language in the statute, which they're just not conceding can happen. There's no explanation. And with regard to the indictment, you have to say if the act is going to apply, you've got to say in the indictment itself, I'm not looking forward to trial, I'm not looking forward to proof. Somewhere in here, in its 4 corners, you've got to say that it applies to those things, and they don't. Thank you, Your Honor.
Your Honor, may I correct one statement?
Sure.
Yeah. Well, you asked me a question. I realized I gave you an incorrect answer.
Okay.
And it was whether this argument of economic or pecuniary harm as a requirement has come up in the last 20 years. And when I answered you quickly, and I'd forgotten, it was argued somewhere in the APS case. It was rejected. The argument was not raised on appeal, but that's less than 10 years ago.
But the order you're going to have on that is just the trial level?
Pardon me, the only ruling was at the trial level.
Okay.
Yeah,
Had I been representing the teachers, I would have
pushed forward. Understood. All right, Ms. Ballmer, how much time do you need?
All right. Good afternoon, Your Honor. I did hear the court's instructions to say basically tell me something I haven't heard yet in the brief, so I will endeavor to do that. I do want to preface my argument by explaining to the court the reason we handled the argument in the way we did by kind of starting with the substantive counts and working our way back up to RICO was to show you the problems that we see with the underlying conduct that the state has alleged in this case. And the reason why we have all these weird crimes like conspiracy to commit solicitation of violation of an oath of office and things that we don't think fit into the substantive crimes is because this indictment is seeking to either criminalize constitutionally protected activity, or the counts don't provide us enough information to prepare our defense, like the solicitation of the violation of oath of office for the legislators, or perhaps the counts charge activity that might be a crime, but it's not a racketeering activity. Perhaps maybe it's something that would be found in the election code, a crime that would be found in the election code, but it's not a pattern of racketeering activity or a racketeering act as defined by our RICO statute. And so because the state is trying to shoehorn this conduct that doesn't fit into a RICO prosecution, you've got to dismiss this indictment. We think it demonstrates the fundamental flaw with their prosecution. So you know our arguments about the enterprise and that we think the indictment doesn't have limits on who could be part of the enterprise and doesn't appropriately define the enterprise. So I'm going to kind of truncate that part of my argument and skip to the next part of my argument, which is about the nexus between the activity in the indictment and the enterprise, because it's interrelated. And that's the part that I know you mentioned, or the court mentioned in its order back in October denying the demur for the other defendants, that the indictment did allege a sufficient nexus and that it did appropriately define the enterprise. But the order didn't provide a lot of detail or facts that the court had relied on. And so I'm going to present some other arguments and facts that I would ask the court to look at and reconsider. So yes, in our view, the failure to appropriately provide detail between the alleged criminal activity and the enterprise is a Kimbrough problem. It's not a general demurrer problem. We're not saying that you haven't alleged a crime, because count 1 does use the words that are in the RICO statute. We're saying you haven't given us sufficient.
But Kimbrough's nothing at all, right? That's the quote. Nothing at all was in Kimbrough.
Yeah, so what
We've got
Kimbrough
something
was,
here.
right, Kimbrough was count 1 is RICO, and then counts 2 through, 50 or whatever are just substantive crimes themselves. They were all VGCSA crimes for the different people. And the Kimbrough Supreme Court opinion listed, here are some ways we can imagine these people could be associated with the enterprise. Maybe they're employees, maybe they're patients, maybe they're doctors, but the indictment doesn't tell us which one of those it is. So look at this indictment with an eye towards my client, Mr. Smith. Same problem. He's mentioned 19 times in the indictment, okay? Every single time he's mentioned, it's in what I've called kind of like the caption of either the count or the substantive act, right? It said we're alleging that this person committed this crime on this date. Except for one, there is one act where it says he and Mr. Schaefer encouraged other people to sign a document, okay? There's no information in the indictment about what Mr. Smith's connection to the enterprise is. Is he a lawyer for the campaign? Did he have some phone call or some email where he's communicating with somebody else who's alleged to be part of the enterprise? That's what we don't know, okay? And this is why we think Boyle is so helpful to our argument. And I know the state says, yeah, but in Boyle, the defense lost. Okay, that's because, the defense was asking for a fairly specific jury instruction. But there is still some very helpful language from the majority opinion in Boyle, right? The Supreme Court did hold that the ongoing organization must have some sort of framework, whether formal or informal. And they said, we agree with the petitioner that an association in fact enterprise must have a structure, that there are 3 structural features: purpose, relationships among those associated with the enterprise, and longevity sufficient to permit the associates to pursue the enterprise's purpose. And very helpfully, I think, the opinion says it's easy to envision a situation where people might engage in a pattern of racketeering activity but not establish the existence of a conspiracy. If several individuals independently and without coordination engage in a pattern of crimes like bribery or extortion, proof of these patterns would not be enough to show that the individuals were members of an enterprise. So I was trying to think of another analogy, and what came to mind was thinking about the protests around what we all call Cop City, right? There have been some people who have been arrested and charged with a RICO enterprise in that case. There's also been other people who have protested. They have the same goal as the people who want to stop Cop City. They've done it the same way. They've gone to demonstrations. Perhaps they've even committed crimes. Perhaps they've committed criminal trespass. Perhaps they've done those things at the same time as other people who are alleged to be in this RICO conspiracy. That doesn't mean that everybody who shows up to protest and to commit a criminal trespass to get to their goal of stopping that training center to be built is in a RICO conspiracy. So look at Mr. Smith in this indictment. The first time he comes up is in Act 23. But there's nowhere in the indictment where it explains, what is his relationship to those who are associated with the enterprise. At most, he is alleged to have committed certain acts either all by himself or at the same time as other people. But there's no allegation of how his acts are connected to the enterprise. That nexus is missing. And that's why count one cannot stand in this case. So let me go back. Now, another argument that I know we've heard from the state about conspiracy and some of the conduct that is alleged in this case is that this is a RICO conspiracy. And they've said a couple things. Number one, we don't have to prove we don't have to allege that 2 racketeering acts were committed because it's a conspiracy. Okay, but you do still have to give us enough information to prepare our defense under a special demurrer analysis, right? And we know that when we have compound crimes like conspiracy, and especially like RICO conspiracy, that the state does have to descend into the particulars and allege how the criminal objectives or goals of that compound crime were going to be reached. So one case that the court can look at for the proposition that a compound crime has to allege at least the elements of the underlying or predicate offense is a Howard versus the state, which is 252 Georgia Appeals 487 from 2001. That was a vehicular homicide case, okay? So the defendant was complaining, well, you've charged me with vehicular homicide and you've alleged that the underlying traffic offense was reckless driving, but you did not allege one of the elements of reckless driving. Now, the defendant didn't succeed in Howard versus the state because the indictment alleged vehicular homicide with reckless driving being the traffic offense, but then it had a separate count. And in that separate count, in the reckless driving count, it did sufficiently allege the elements and the details. So what does this tell us? What does Howard tell us? It does tell us that an indictment has to either allege the essential elements of the predicate offense or charge the predicate offense completely in the separate account, or somehow in the indictment put the defendant on notice of the predicate offenses by the facts alleged in the indictment to show how the compound crime was committed. So either put it in the top level, the predicate offense, charge the predicate offense, put it in the top level, put it in the compound crime, put it in a totally separate predicate offense charge, or else allege somewhere in the indictment how they are connected, how the predicate offense is connected to the compound crime above. Another case that stands for the proposition that RICO is a special type of compound offense, not simply a more serious grade of forgery, robbery, homicide, or other predicate acts, is the Cotman case, which is the APS case. In that case, Judge Dillard said, this is a compound crime. Okay, so put those two cases together, and that tells us, yes, it's a RICO conspiracy, but you still have to give us sufficient detail of how the conspiracy's, objectives were going to be achieved. What is our relationship to the conspiracy? What is Mr. Smith and the other defendants, what is the relationship to the conspiracy? It's got to be something more than just, you all had the same goal. Maybe you were committing the same acts on certain days. And maybe you had the same objectives. You've got to have that nexus. And that's what we don't have here. The indictment does allege that we functioned as a continuing unit for a common purpose, but never goes on to explain how anybody functioned as a continuing unit, particularly Mr. Smith. It does also in different places in the indictment. It says things like that the criminal conspiracy had the goal to unlawfully change the outcome of the election in favor of Mr. Trump. Okay, that's not a RICO conspiracy. The conspiracy has to be you had an agreement that somebody was going to commit 2 acts of racketeering activity, not 2 crimes. So that's not sufficient to allege a RICO conspiracy in this case. It does have a bare bones, 1-sentence allegation that the conspiracy's common plan and purpose was to commit 2 or more acts of racketeering activity in Fulton County and elsewhere. But nowhere does it give sufficient detail as to the connection for Mr. Smith or the other defendants to the conspiracy's common plan. That's what's missing. The enterprise that's alleged in the indictment, I know that the state says our argument is like, the sky is falling, and that it includes anybody and everybody. Our argument is not that broad, but our argument is that the state hasn't sufficiently cabined the enterprise to fit within a RICO conspiracy, because the indictment alleges that people who were part of the enterprise, which is an association in fact enterprise, reaches far beyond just the 19 people named in the indictment. It includes unidentified co-conspirators, people known and unknown, people in Georgia but outside Fulton County, and people across the country. That's too broad to sustain or to pass a special demurrer analysis in this case. We know that there were millions of people who did and perhaps still want or still believe that President Trump won in 2022. There were thousands, maybe even hundreds of thousands of people who took various actions to try and challenge and overturn the results of the election. There were thousands of people who engaged in unlawful activity to accomplish that goal. Criminal trespass, disorderly conduct, even more violent actions. Even those people who had the same goal and perhaps took steps that constituted crimes to reach that goal still doesn't mean that they are part of a criminal RICO enterprise. Your Honor, I think I have covered everything that's different or additional to something that you've already heard from us in our briefs. So I will just sit down, and I would like just perhaps a few minutes, if necessary, to respond to Mr. Floyd.
All right. Thank you, Ms. Palmer.
Your Honor, could we get an opportunity to screen share, please?
All right. What's the host name?
State of Georgia.
State of Georgia.
I probably should have done that one.
Mr. Derryberry, if we can have the State of Georgia as a co-host.
They're a co-host now.
Thank you. Your Honor, Kimbrough does not control here. I mentioned 1614-2B as the provision that launched 1,000 demurs. Kimbrough is the case that has launched 1,000 demurs, and my friends in the defense are very proud of their win in that case, and that's fine. That's all great. But Kimbrough is not the universal get-out-of-jail-free card that they would make it. As you pointed out, the court in Kimbrough said actually said one thing. There's a second one that's a corollary to it. The first was that indictment said absolutely nothing about any relationship between the acts of racketeering activity and the enterprise. It gave 3 examples, federal case law, where the allegations were adequate. The second part is the court said specifically, we are not saying we want pages and pages of detail about these relationships. And that's the bookend on this, okay? And so we're not in a situation, again, where we get this creep that is the state has to allege every single detail, has to tell the defendant what his own motives were, has to tell the defendant everything we have that he did that we think exposes him to liability. No, that's not it at all. And there is no Georgia case that says that. And so we have 2 things going on here. We have a specific argument primarily regarding the Boyle factors, and then we have more general statements about pleading. I'm going to try to jump to the Boyle aspect of it first, but this is really the last argument Ms. Clark-Palmer made. And so that began because the defense clearly recognized they'd overshot the mark in their brief, and so they disclaimed their argument that basically we would, if I recall right, we'd have to start converting football stadiums into prisons to incarcerate all the people who are uncovered by this enterprise. No, that's not true. First of all, there's no such number of people charged. And second of all, this is based on a straw man argument. The enterprise in this case does not consist of thousands, hundreds of thousands, or millions of people. It does not consist of everybody who voted for Donald Trump. It does not consist of everybody who supported Donald Trump or everybody who ever asked a question about about the relevant election in 2020. We don't say that. They don't get to rewrite our indictment for us. Okay? Another basic principle of Georgia law. It's just not in there. The fact that an indictment says there are persons involved unknown to the state is completely unremarkable and means nothing in this context. Here's the difference. Act 95 in the indictment. Defendant Trump placed a call to Rusty Bowers, an individual who has spoken out a number of times about what happened, the Speaker of the House of Arizona Representatives, in which the indictment alleges Mr. Trump solicited, requested, and importuned Mr. Bowers to unlawfully appoint presidential electors from Arizona, something the indictment says he also did and his Confederates also did in at least half a dozen other states. In that call, Bowers stated to Trump, I voted for you. I worked for you. I campaigned for you. I just won't do anything illegal for you. And therein lies the difference. Bowers did not join a conspiracy to unlawfully overturn the election. Okay? And to say that's not a RICO conspiracy is ridiculous. Okay? The definition of a RICO conspiracy is set forth in Cotman 2. And it basically says a person who knowingly and willfully joins in I'm going to slightly mischaracterize, it's actually in the PowerPoint I'm going to show in a second, basically an endeavor that contemplates committing 2 or more acts of racketeering activity. Not that they have to commit them, not that the acts have to be committed. We've laid this out in our briefs over and over again, citing the United States Supreme Court's decision in Salinas, which makes it abundantly clear you don't have to commit a violation of the substantive offense to commit the conspiracy offense. That's not how conspiracy works. Otherwise, conspiracy would accomplish nothing. Okay? It is enough to insist, to provide assistance. It is not necessary to commit the substantive violation. Therefore, it follows it is not necessary to engage in the acts of racketeering activity. So everything you just heard about not identifying acts of racketeering activity falls out in a conspiracy case because it's not an element. It is relevant at trial. And United States versus Elliott makes this point. While the conspiracy requires that there be some contemplation that acts of racketeering activity will be committed, they are not required. However, of course, if the defendant actually engages in it or his co-conspirators actually engage in racketeering activity, that is certainly evidence of the agreement and entirely relevant. But the fact that it is admissible evidence does not turn it into a pleading requirement in a conspiracy case. Okay? Nobody has been charged with voting for Donald Trump. Nobody has been charged with working on the Donald Trump campaign, soliciting a vote, calling, trying to raise money. None of that. People have been charged because they did something illegal for him or they assisted other people who were doing something illegal for him. The state has identified specific persons in that conspiracy, both the defendants, and has provided the identity of the unindicted co-conspirators. It's made it clear that the enterprise's common purpose was to unlawfully overturn the election results and to do it through a pattern of racketeering activity. The state identified 161 overt acts in furtherance of that and identified relationships between those persons, identifying specifically people who acted together. These people, according to the indictment, and the indictment is read as a whole, and it is read in the light favorable to the state, okay, it shows 2, 3, 4, 5 or more persons acting together. They communicated, and we allege that. They coordinated, and we allege that. They went to meetings together. They traveled together. They talked to each other. They talked to each other about what they were doing in furtherance of the conspiracy. As Boyle observes, the existence of an association, in fact, is oftentimes more readily proven by what it does rather than by an abstract analysis of its structure. And I think that language is clear here. I'll point out that the indictment, since Boyle has been invoked, could you skip to slide 44, please? And as encouraging as that may be, I can't promise I won't go to some of the earlier ones.
I think we're gonna have to move on here shortly, Mr. Flores.
All right.
I'll give you about 3 or 4 more minutes.
All right, Your Honor, I'm at your pleasure. First, Boyle has not been adopted by the Georgia courts, so it's not Georgia law. But second, if it was, and knowing the possibility that it was, clever little fellows that we are, we studied it carefully, and we followed it. Okay? And you heard those 3 requirements that it operate for, and I'm doing these in a slightly different order than they're actually stated in Boyle, that it operated for a period of time sufficient to permit its members and associates to pursue its objectives. We specifically allege that on page 15. Okay? And 161 overt acts show nearly 2 years of activity that consisted of a frenetic, coordinated, nationwide pursuit of those objectives. So that's all over the indictment. The defendants and other members had connections and relationships with one another and with the enterprise. We show that. Okay? We allege that expressly, same page. It consisted of an ongoing organization whose members and associates function as a common unit for a common purpose of achieving the objectives of the enterprise. Same page, 15. Boyle is all there, laid out. What they're saying is we didn't plead our evidence in support of it. That's not the requirement. Also, by the way, as to the longevity argument, in Georgia, only 2 acts are necessary to constitute a pattern. Your Honor recognized that in an earlier ruling looking at the binding Georgia Supreme Court case of Dorsey v. State. So establishing a pattern of racketeering activity, were it required, and it is not, is something that happened very early on in this, and they continued to pursue it. Will you take me to 1, please? I have a couple of points in these early slides I'd like to make very quickly, if Your Honor will permit. And I'll provide the court with this indictment, with the PowerPoint, and so that you'll see the sites. That way I won't have to go through that. But when we say sufficient information, let's look at what is happening here. First of all, we're not required to plead the evidence. That's clear. I cite Stapleton for that. It is not necessary for the state to spell out in the indictment the evidence on which it relies for conviction. Noticeably, Mr. Smith's argument avoids the actual Georgia RICO cases that talk about the sufficiency of an indictment. The main ones being Grant, which you cited in your October 17th argument, and Pasha itself, a Georgia RICO conspiracy case. They go through this. The indictment clearly gives Pasha notice of the nature of his involvement, the overt acts attributed to him, and the underlying predicate offenses. That's it, all that's required. Grant, the requisite predicate acts and enterprises comprising the charges against appellants are precisely described and named in each instance. No greater detail was required to allege the RICO offense under Georgia law. Those are the controlling cases. When the argument that is being made to some extent, and in the PowerPoint, we go through this, the standard under federal law is exactly the same for the sufficiency of the pleadings, and we provide about a half a dozen examples of federal cases reviewing the sufficiency of indictments, and they don't require any of this. Could you take me to 14, please? And I realize time is coming to an end, and I'll go through this quickly, Your Honor. So the argument you heard is, we don't say anything about the relationship between these defendants. Well, we laid out 161 overt acts. Some of them are committed by an individual. That's the only person acting. An example would be perjury. There's only one person who testifies. A voicemail left. There's only one person on the phone, all right? But there are quite a few where these individuals act together. And when you look at it, these are each on the screen, each examples of overt acts where individuals are acting collectively. They're acting in groups. Trump with Giuliani 5 times. Trump with Meadows 3 times. Trump with Eastman 4 times. With Ellis and with Powell. What happens? How do those people connect? Giuliani connects to Trump, to Meadows, to Eastman, to Powell, to Ellis, to Chesbrough, to Smith, to Chile. I have not put all the defendants on here because life is short, but I think these examples are sufficient. Eastman, in turn, as we know, connects to Trump and Giuliani, also to Ellis, also Chesbrough, also to Smith. Smith connects to Giuliani, Eastman, Ellis, Schaefer, Chile. You notice you're seeing many of the same names over and over again. You're seeing groups of 1, of 2, 3, 4, and 5 people acting together. Those are the relationships that Boyle talks about. They keep doing these things. This isn't them having lunch together. They're not playing fantasy football. These are overt acts in furtherance of this conspiracy. Chile breaks the bank. He connects to at least 10 of the defendants in this case. These are all overt acts where they're communicating together, where they're acting together, where they're moving in furtherance of this criminal endeavor. More than sufficient to satisfy any requirement of a common purpose or of a relationship. I'm happy to answer any questions you have, Your Honor, but
All right, if you could email that to us.
It will be done.
Appreciate it. All right.
Thank you.
Last thought, Ms. Palmer.
Yeah, last. I think that everything Mr. Floyd just said about what's on page, it's on page 15 in the indictment, about what they allege as to the enterprise, helps them survive a general demurrer, but not a special demurrer. And that's what our complaint is. I agree with him. They don't have to plead their evidence. I agree that they don't have to plead or prove that 2 predicate acts were actually committed, but you got to give us something. You have got to give us something that tells us what is our connection and relationship with one another. And the last slide that he pulled up that said so-and-so connects to so-and-so, I have this memorized as to Mr. Smith, so he's the one I can speak to. What that means is he's in the same place at the same time. And if we were robbing a bank, okay, that would be problematic because there aren't millions of people or thousands of people who are out there on the same day at the same time in the same place trying to rob a bank. But in 2020 and after, there were thousands of people, maybe even more than that, who were in the same place at the same time, undertaking the same efforts with the same goal vis-a-vis the 2020 election, and that doesn't mean they were in a RICO conspiracy together. One point I want to say just about Grant, because I know the court did cite to that in your previous order in October. Grant was a much more clear-cut, so to speak, case. It's the timber case, right? The indictment alleges an association in fact, but says in the indictment that it was part of the criminal enterprise for the people associated within the enterprise to inflate or deflate the value of timber. I'm skipping over some words just for time's sake. Forging contracts about the timber. It goes on and on. The success of the criminal enterprise depended upon the cooperation of the defendants to move the timber product through their various companies until its origin or final destination was hidden from the true owner. Okay, so that's the information we're asking for. We're asking for the state to tell us give us something about our connection to the enterprise. And it's something more than we were in the same place at the same time on the same day, stating our beliefs. And when they say overt acts, again, as to Mr. Smith, every overt act except one, every overt act matches up to a substantive count. It's just you committed a crime in this place on this day. It's not you made a phone call, you sent a tweet, you sent an email. It's not anything that would address his relationship and connection with the other people alleged in the enterprise. Thank you.
All right, thank you, Ms. Palmer. So I want to transition over. We had listed out several of the other issues now still pending. I think the thought might be here. Let's, if the folks, we haven't been too boring to the folks on the Zoom call. I think we want to check in with them, see if they're still with us. And I think we would start with the motion to withdraw. And then we can transition over to Mr. Sadow's motion and Mr. Giuliani's motion after maybe a short break for the transition. So with that, see Mr. Cohen's here. Do we have other counsel? All right. So we could perhaps make some room at the council's table. We'll move over into the motion to withdraw. And you might want to, like I said, check in with as of now, your client to see if she's still with us. And I can see a box, but I don't know if she's.
Good afternoon, Judge. This is Steve Greenberg. I just don't have my video on because I know we're not supposed to speak on the Zoom, but I just texted her to turn hers back on.
All right. Thank you, Mr. Greenberg.
Thank you. We're dressed to shovel here in Chicago today.
All right, Miss Cootie, are you with us? I think I still see you muted, ma'am.
I'm here.
All right, great. Can you hear us all right?
I can.
Okay, so Ms. Cootie, just a few things I wanted to take up with you. This shouldn't take more than a minute or two. On December 18th, Your current counsel, I think that's Mr. Cohen, Mr. Greenberg, and Mr. Herman, had filed a motion to withdraw from representing you in this case. And in that motion, they said that they have informed you of a few things, including that going forward without counsel can be, is usually not a good idea, and encouraged you to obtain new counsel. Did you get a copy of that motion or that notice, or did you have a chance to speak with them about what it would mean when they withdraw?
I haven't spoken to Mr. Cohen at all, but I have received a copy of the notice, and I have spoken to Mr. Greenberg regarding that. Yes.
All right. And we didn't get any kind of an objection to that within, I think it's the 10 days. And so at this point, ma'am, I believe your attorneys would be allowed to withdraw from this case. And so that leaves you without an attorney upon the signing and the filing of that order. So there's a few things I want to go over with you here, and we can kind of get a sense of how we're going to proceed. So obviously, you always have the ability to hire another private counsel. You also have the constitutional right to represent yourself, but that's something you have to do diligently. We can't delay things simply as we wait for you to find alternate counsel. So you also have the right, if you can't afford it, to public representation. And so I guess my first question to you would be, is that something that you're interested in exploring to see whether you qualify for public representation?
No, sir. I will be attempting to retain one of the lawyers that is on this call, and then number two, seek an additional counsel.
Okay, and who would that be? There's someone on the call right now?
Greenberg.
Mr. Greenberg, you're trying to retain him?
Yes.
Okay, I think he's one of the ones who filed the motion to withdraw, though.
Correct. And we've had conversations on attempts to move forward. So in this case, I think he understands particular arrangements that will be made. And I do understand it is his decision at the end of the day, but that is my thought and my approach on this situation.
Okay,
Your Honor?
Yes, sir.
May I explain? Because I don't like talking in circles. So, and I think I want to make the record clear. So I have known Ms. Cootie for a long time. And when this first came up, even before the indictment, I said I would help her out. And she had the belief that people were going to be able to assist her in meeting what I perceive to be fairly minimal professional obligations, given the scope of the work. And unfortunately, those people did not assist her. So if at some point in the future, she has the ability to have private counsel, I would be willing to assist her. I've gone over the discovery, received all of that. But at this point, given the fact, especially where the prosecutors are saying it's going to be at least a 4-month trial, I just simply can't help her as a friend. And so I think that's what she's referring to.
All right, so you're still pushing forward and would like the court to grant this motion to withdraw, this unobjected to motion to withdraw, Mr. Greenberg?
Yes, Your Honor.
All right, so Ms. Cootie, it sounds like that you have a game plan, is that you still want to see if you can get Mr. Greenberg to sign up, but if not, you've got some other options in mind that you're pursuing. And is that accurate?
That's correct.
Okay, so that's just what I wanted to emphasize, is that I would urge you to continue to seek out that private counsel, not to put this on the back burner. And because I have to caution you that simply if it gets to within a trial date, whenever that is, or another hearing date that's very important to you, if a counsel comes into this case the day before, the week before, even a month before, and asks for a continuance, that's probably not going to be granted because, again, you have to show that you've exercised reasonable diligence in obtaining private counsel. Does that make sense?
That makes a lot of sense, yes.
All right, so the idea is I'm probably going to also be bringing you back for a very similar situation in a month or two to check in to see where you are with obtaining private counsel, all right?
Correct, thank you.
All right, do you think there's anything else we need to go over today then?
I think not. Thank you so much.
All right, thanks for joining us. That'll be all. Ms. Goody, thank you.
Thank you.
Okay, and Mr. Cohen, Mr. Greenberg, I'll have that proposed order signed on the docket. Thank you all.
Thank you, Your Honor.
All right, did we have counsel for Mr. Giuliani with us as well? Yes, sir. All right, as you're coming up and get situated, why don't we take 5? I'll come back, and then Mr. Sadow will kick it off with your motion to compel.
Fine, Your Honor.
All right, I'll be back in 2:45.
Well, I don't know.
Okay, good afternoon. Let's go back on the record. And next up, we have a motion to compel discovery filed by Mr. Sadow on Monday. And Mr. Sadow, I just want to make sure I don't cross my wires here. Is this solely about these videos, or has this now expanded to be something? There's been a flurry of emails here. Is this broadened? What is it that you're seeking to compel?
I'm specifically seeking to compel at this point material that may have been shared by the J6 committee with the district attorney's office, for which the district attorney's office apparently was not permitted to maintain or preserve or keep, but was able to view what appears to be April 18th through 21st of 2022.
All right, so you're not asking for correspondence like I think Mr. Clark just filed a motion. Is that right?
Well, I had asked originally, let me see if I can preface it in this sense. The motion to compel asked for the response of the J6 committee or the former chairman Thompson to Ms. Willis's letter, which is attached to the motion to compel, in which he asked for videos and other material which would help further the district attorney's investigation. I also became aware that there was a video presentation made to the special grand jury as to two Department of Justice officials, Mr. Rosen and Mr. Donahue. I included that in the motion to compel, as the emails going back and forth over the last couple of days indicate. I asked for it simply whether it had been turned over in discovery. I asked for it 3 separate occasions. The district attorney's office, in its infinite wisdom, chose not to respond to those email requests. And then after I filed the motion to compel, which of course took a little time to put together, decided that they would say, yes, it's in the discovery. So to the extent that it's in the discovery, that part of the motion to compel is no longer before the court, although I must say I find it somewhat troublesome, trying to keep it at the base level, that I would be forced to file a motion to compel for the DA's office to respond by saying yes. It doesn't seem to make a whole lot of sense. And under those circumstances, I'm sorry if that's wasted the court's time at all. That's not my intention. So we move back to the response that I had sought from the J6 committee and former Chairman Thompson. The DA's office refuses to turn that over. It wasn't until Monday, when another motion was filed by defendant Roman, that I was able to access invoices which indicated that, in fact, the J6, some members of the J6 group, I don't know whether they are the actual committee members or people or staff, met with Mr. Wade and apparently another prosecutor, as well as investigators from the Fulton County District Attorney's Office. And as I said, the invoice in my supplement indicates that that initial meeting appears to have occurred sometime from April the 18th to April the 21st of 2022. So what I won't call it expanding, but what I'm trying to do is find out what it is that the J6 committee allowed the DA's office to get access to. I'm assuming everything that the DA's office actually received, a physical document, they've turned over to us. I'm not suggesting that they are in some form or fashion not fulfilling their discovery obligations. The concern I have, and which is also represented now in the Politico story that I have sent along as part of another email, that appears that they were given the right to review material for the J6 when they were there, but weren't permitted to keep it. I don't know what they reviewed. I don't know whether what they reviewed hasn't been turned over to us, but I'm trying to find a mechanism to determine if there is information that the district attorney's office had access to under restrictions that we ought to be able to gain access to, because it may be material to the preparation of our defense. Is it technically within 1716-4? No. Could it be within 1716(7) if it relates to witness testimony? Yes. But I've also cited to the court, and the court has certain inherent power to grant us, under the circumstances of this particular case, in the interaction between the J6 committee, which obviously is the U.S. Congress, and the district attorney's office, so we have federal and state involvement, a means by which we can determine if there is material, as I said before, that the district attorney, particularly Mr. Wade and his investigators, were allowed to look at, but not allowed to actually obtain or receive. That's the thrust of this motion to compel. I'm not suggesting that there's been any wrongdoing. This is not a J6 shouldn't have shared with DA or vice versa. This is just trying to get to the basic notion of what it is that may be out there that was shown to the DA's office that they don't have for any reason, and therefore we can't put our hands on. And to make it one more step forward, we know through our investigation, and that includes information that I have received from defense team members for President Trump in the DC case, that there has been the destruction of evidence by J6 committee, including videos of interviews and potentially deposition testimony. There are no such videos of that type that's in the DA's disclosure or production here. There is videos, which I've now been pointed to, that were done publicly. I'm not talking about that. I'm talking about what would be private interviews or private depositions. So I don't know whether the DA's office had access, viewed those, compared notes of investigators, but that's the thrust of where I'm coming from.
All right, let's see if we can narrow it in and focus it just to see exactly where we are. So, Ms. Young, let me start with
And it
a
seems
few of these.
now that Mr. Sadow has kind of clarified what his request, and I'm assuming that's separate from the motion that Attorney McDougal may have filed, because it's a little bit different than what was actually posed to the state originally. So what I heard Mr. Sadow say at the end of his request is that he's asking for anything that was private, that was shared with the DA's office during this meeting that was had by Mr. Wade and Mr. Wakeford. I just want to make sure before I answer that question that that is what he's asking for, so I can answer it accurately.
Right. So
May I respond?
Sure, Mr. Sadow.
Yeah, and because I don't want to make this any more difficult than it may already be. I am aware for certain of the 418 to 421. I know there were phone calls thereafter. I don't have any evidence that other information was shared of a material nature, that is physical nature. So that's why I have focused on the mid-April activity. But yes, I also am still seeking the response, if there was one, or there is some, from the J6 committee. And I'll just, so that the court remembers, the DA's office sent around to counsel on September 27th of 2023, something that they called their open file policy, which basically is, if it wasn't privileged, it's not work product, have at it. We'll show it to you. That's where I'm coming from. So yes.
Right. And so when you say the word response, it's not potentially, let's say, an email from the committee saying, how are things and whatever else. It's actual documentary evidence that may have been turned over. Is that fair?
It's fair to say, if you look at the exhibit to the motion to compel, exhibit number 1, that is the one that was filed on January the 8th. That's District Attorney Willis's letter to Honorable Benny Thompson, in which she asked for recordings, transcripts of witnesses, interviews, depositions, electronic and print records of communications, and records of travel. I wanted to find out if the chairman responded by saying, we will give you access to such and such. Let's make arrangements for you to see such and such. That's what I was looking for in the response. If his response back was, thank you for your letter, we'll be in touch.
Sure. So I think there's two parts.
For them just to tell me.
I think there's two parts we got to flesh out here. So I think the first question to the state would be, is there anything actual physically that you were provided that has not been turned over to the defense that was given to you by this committee?
And the state's answer is no, Your Honor. The state has repeatedly said that we have turned over all exculpatory evidence that we have received to all defense counsels on multiple occasions. There is nothing that we received from Jan 6 that has not been turned over to all defense attorneys. And the state will also say everything that we turned over are all things that were publicly out there. And we actually got it from a public website. It wasn't even actually something that was sent to us by the Jan 6 committee. We downloaded it from the public site in which the Jan 6 committee had put everything out that was handled during that committee session.
All right, so that would be their answer to part one. Part two, then, which is a little more legally uncertain in my mind, is were you allowed in the room with other documents or exhibits or what could be characterized as evidence, allowed to look at them, watch them over and over, and then leave with just whatever is in your head or your notes?
And Mr. Wade is going to answer that question, Judge, since he was the one that was present and not I.
All right.
So, Judge, I think that I could provide some insight to both of the last two portions, which would be the response letter portion of Mr. Sadow's motion, and then the evidentiary portion that the court is inquiring. Firstly, D.A. Willis did send over a letter to Chairman Thompson requesting certain things. The tone of Mr. Sadow's letter led us to believe that, okay, perhaps we are missing something and we didn't provide something in discovery. So the time period that elapsed was due to our elaborate search to make certain that we didn't fail to provide or turn over something that was in existence. Even as late as last evening, we reached out to Chairman Thompson to make certain that he didn't send over a response and we just missed it or didn't receive it. So the answer is no, we never received a response, a written response from Chairman Thompson. Does not exist. And the only reason for the time lapse is because we wanted to search, and double search to make certain that our response was an accurate one. As it relates to travel to D.C., Chairman Thompson shared with us during this conversation regarding the letter that his directives were that we were allowed, we being the district attorney's team, would be allowed to have a conversation with his investigative team. We were not to share any information. We were not to exchange any information. We could have a conversation. If there was something that we wanted to show them, we were allowed to do it. If they wanted to show us something, we were allowed to have a look at it. But there were no photocopies of anything, and there was no sharing of tangible documents of any kind.
Would you agree, though, that let's say if this investigator had told you something that completely contradicted a statement that you'd received from a material witness that you'd already turned over to the defense, that you would then have to document that in some way or turn it over as part of a Brady obligation?
I believe that, yes, sir.
All right. And are there any concerns here from what you spoke to with these investigators reaching that level?
Absolutely not, Judge. In fact, everything that was shared in that conversation was made publicly available through the Jan 6 committee when they released all of their documents. So everything that we talked about, everything that they shared was publicly released.
All right, so Mr. Sadow, turning back, as I hear the response to part one, it's that they never got any kind of a formal written response from the chairman for them to disclose to you. And then on part two, yes, they did have a meeting and they spoke to investigators and they maybe shared notes in the metaphorical sense, but they don't have anything physical in addition to what's already been turned over to you. Any reactions to that?
Well, I take them at their word that there was no response. It would have been fine. Might have made this whole proceeding a bit easier if they had simply said in response to the several times that I had asked, we're looking for it, we'll let you know, as opposed to no response at all, or we're not going to respond to you at all. But the other part of this is, it appears that there was a extended communication conference in which information was shared. Now, Mr. Wade has not indicated whether or not they actually gave him documents or materials that they could review, as opposed to just communications or conversations. So I'd like to know that. And to the extent that Your Honor has already hit on it as to whether or not there may be exculpatory evidence or otherwise potentially inconsistent Giglio type evidence.
All right.
My question would be, were there notes taken by their investigators, the DA's office investigators, and or by the attorneys that are still in existence that could be supplied to the court for an in-camera examination to determine whether or not there is anything that the court would deem to be potentially disclosable under either its inherent power, which I've mentioned, or under due process considerations, exculpatory evidence, Brady, Giglio. So that's my follow-up.
All right. A lot to unpack there, but I'll just turn it back over to Mr. Wade at face value.
Again, Judge, everything that was shared was released publicly through the Jan 6 committee. We don't have anything that they hadn't released publicly. There were no notes taken that we would need to turn over or that has something in it other than what was publicly released. Our investigator hadn't.
Just to be clear, you're not claiming you didn't take notes, as I would think most lawyers would, but the idea is that you have notes and you believe those are work product.
Yes, sir.
And you've reviewed those notes, and as of now, as the evidence stands, you don't see anything rising to the level of Brady material.
Nothing at all.
All right.
If I may just address the first point that Mr. Sadow made in regards to the state answering yes or no to his question. The state still stands firm on the state's not required to answer yes or no in regards to whether or not they received a letter from Mr. Thompson. What
You're
the
not
state
required to, but it doesn't make the issue go away, right?
No, Judge, but the state is fully aware that if we did receive information and documents, that we should turn them over, and we have turned over what is public out there. So I just want I want the court to be clear that the state was not just not answering a question for Mr. Sadow. The way that it was posed is though they were looking for communication, attorney work product, which they're not entitled to. And that is why the state did not respond as Mr. Sadow wanted the state to respond. We responded that yes, you have all evidence that you're entitled to through the discovery statute, through Brady, and any exculpatory evidence that may be in the state's possession. All of those things have been turned over.
All right. And Mr. Sadow, I think I take your point. I understand where we are. I don't think we need to dwell on this too extensively because unless it starts flaring up again and again. But I think
and I understand that, Your Honor, and I appreciate that. These kind of disputes, so to speak, do not need the court to waste its time dealing with. That's something that counsel should be able to handle. If I may ask one other question, were the investigators from the DA's office or the attorneys, when they were in conference or when they were with the J6 committee or members of the committee or their staff, were they permitted to view any videos that have not been made public?
The answer is no, Judge.
All right. All right, Mr. Sadow, if you ever receive any other indication that that is not the case, you can renew your motion and take it up at that time. However, at this point, based on what's been alleged in the original motion, it seems like that is moot as to the videos presented to the grand jury and as to the supplemental part. It seems like those concerns have been addressed with the caveat of could have been done in an email, perhaps, but we'll see.
Perhaps.
All right. So anything else, Mr. Sadow, then?
Yes, Your Honor. I was told via email that all the lawyers were told via email that you would briefly discuss the notion of adopting co-defendants' motions. Specifically, I had asked in reference to the motion to dismiss and disqualify filed by defendant Roman's counsel on January 8th of 2024. I had sent an email along asking for leave to adopt at a later time. Does the court want to take that up now, or do you want to take that up at the end?
No, I think we can address that now. So I'm remembering that just kind of addressing the adopted motions because they've gone every which way here to try and impose some sense of order on this is that the conclusion had been you can adopt a motion, but that doesn't necessarily entitle you to argument on it. But then I recognize when you have a drop dead motions deadline, you don't necessarily have time to adopt your co-defendants because they just got filed simultaneously. So in essence, are you asking just to adopt it on its face, or are you looking to supplement it and go much further than where it already is? Or
Well, actually, neither one.
Joint counsel at the table.
Well, actually, neither one at this point. This is the first motion in which there have been allegations of fact made, which deal directly with our opposition counsel. Suffice it to say that they are salacious and scandalous in nature, and I don't have a factual background that I can state to the court supports that at this point. I'm leery of moving to adopt motions that make such allegations without having a better understanding or substantiation of the allegations. What I'm trying to do here, it's one thing to adopt a motion that brings up a matter of law. This is different. I was hoping the court would give me the opportunity when the DA's office responds to that motion to see what the factual disputes are, what the allegations, whether they are disputed otherwise or whether they are supported, to give me the opportunity within a few days of that response by the DA's office to make the determination whether I wish to adopt. That's specifically what I was hoping to accomplish with regard to that specific motion. Otherwise, I should be able to adopt motions right away like I did. There were certain things that were filed on January the 8th by co-defendant counsel, and I immediately adopted those on January the 9th. But this is different. That's why I put it to the court as I have.
All right. So obviously my plan with this was to allow the state an opportunity to respond before setting a hearing date. And as for the date of a hearing, we have to work around the other trial calendars in this docket. So I think early February would be the soonest that would happen. And so I think that would give you some time, Mr. Sadow, to consider any adoption if you need to. Again, I'm not opposed to just merely adopting it to preserve the issues if that's something you do want to join. So to that end, I would say you do have some leeway there, but at the moment when we've got a response from both sides and we're ready to set it for a hearing, what I'm trying to avoid is dragging it out because other parties want to piggyback and do their own separate investigation, if you will. There's a motions deadline and we're trying to stick to it. Am I making sense?
I understand that, Your Honor.
All right.
Yes, totally. All I'd ask for then is if you'll give me 2 days to adopt after the response. I need no additional time after that.
All right.
May I just briefly address that?
Sure. And
Craig Gillen.
Mr. Gillen, for the record.
Our motions are due February the 5th.
Right.
Now, we are looking at that motion which has been filed. We're going to do our own investigation and determine whether or not we're going to adopt that motion or supplement that motion. Just want you to know that that's what our timetable is.
All right. Understood.
Thank
you. Does the state want to add anything?
Not at this time, Your Honor.
All right. Anything else, Mr. Sadow?
No, I take it the court will give me at least a couple of days after the response. I'll get it in immediately.
All right. Yeah, like I mentioned, I don't know when the state is planning to file a response, but at some point we will have to set it for a hearing. And right now, again, like I said, just based on the schedule, we're targeting early to mid-February. So I would imagine if there's going to be a response, it would be before that time. All right. If that is all, Mr. Sadow, I think we're going to turn to Mr. Giuliani, and unless you're free to stay on if you want to.
Thank you, Your Honor.
Okay. So if we could have counsel for the record, your first appearance for the record here.
Alan Stockton for Mayor Giuliani, and John Esposito and David Lewis, I think, are attending virtually, and I think the mayor may be watching on YouTube.
Okay. All right. Well, welcome, Mr. Stockton. I saw two motions pending that we could take up today and address. I wonder if we could start One of them seemed a bit more straightforward than the other. So your motion asks for interviews with the co-defendants who have already pleaded guilty. As I understood it, there was nothing prohibiting that, especially from counsel. If you need clarification on that, we can give it. But your motion goes a step further and says you want to compel interviews. And I think we've got some clear case law in Georgia that says I can't do that.
Judge, I think we can take this out of your hands for the time being.
I'm welcome to hear that.
Been talking with the state, and on this issue anyway, we've agreed that the issue of whether or not they could be compelled will be reserved. I think there is some law that if the court saw it our way, that you could justify compelling them to discuss the case with us. But what the state and Mayor Giuliani's team have agreed to is that we would just put that issue, just put a pin in that and wait. We believe that we'll probably be able to talk with these people. The only issue we're dealing with, yes. The only issue we really have is the state is wanting to either be present or have recorded any interaction we have with these co-defendants that have already pled. Judge, my understanding, there's a case Shields versus State, the closest thing I found, and basically that's 264 Georgia Appeals 232, and basically what that just kind of provides in the periphery is that if we were wanting to speak to one of these co-defendants and they would refuse to speak to us without the state being present, that's that defendant's or that witness's prerogative. But otherwise, we would submit it. It wouldn't be proper for the state to be part of our investigation, just like we weren't part of theirs. We weren't there when the proffer videos were made. We didn't get to be a part of that. But that's the only issue I believe we've got on this is whether or not the state is entitled to be present and or record or have a recording of that.
Well, I think we end up coming full circle then. I don't know if we can kind of neatly avoid the main issue, which is my understanding from stretching back from the Georgia Supreme Court was the state can't deny you access to a witness, and they shouldn't be instructing their witnesses not to talk to you, but that the ultimate decision rests with the witness themselves. So if they, and that the witness can set any conditions or preconditions that they want.
Correct.
So if any of these folks want the state to be there,
and that's not our issue.
I think they have to be.
Yeah, no, that's not our issue. Our issue is the state is saying they want to be there.
Sure.
And we don't want the state to be there unless the witness requires it.
Sure. That's my understanding of how it works and the state of the law, but I'm willing to hear if otherwise.
Well, that's all I have from our position on
Okay.
that.
Let's see where we are.
Alex Bryant for the state. Very briefly, we do insist on that condition of either the state being there or having these videos recorded. Mainly we have probation conditions and we have bond conditions, and they're there for a reason. There's make sure that there's no harassment, no influencing the witnesses, no intimidation going on, and these are measures that would be able to remedy and be protective of those purposes and still be in line, in conformity with those probation conditions and why they were imposed. As to the video recording, I think there's a second purpose in that there's an efficiency purpose. Once they're recorded, we've got 15 defendants. You know, we don't want to have to subject these witnesses over and over again to interviews, and especially have to repeat themselves over and over again to each defendant. So I think a video recording helps alleviate those concerns, and also to help alleviate our concerns that they were being undue influence or intimidation, because they know that it would be video recorded and be turned over to the state.
I think it's, you know, what you're proposing may be the most efficient thing, and certainly not completely unreasonable, but I'm wondering if this is just a kind of the necessary baggage of having a multi-co-defendant case. you know, based on the nature of the questions a defense counsel might ask a witness, they could consider that as revealing their strategy or where their focus is going to be, and saying that one interview is going to be able to satisfy every single other co-counsels may be a bit too optimistic as well. Everyone might need to be going down a different road. So I mean, I can see the point. I don't think that's going to be one that we're going to be able to satisfy there.
Also, don't think we need an order yet because there's been no discovery violation at this point. We've turned over the proffer recordings, we've made available these witnesses, we've given their contact information, and there's been, as to these probation conditions, there's been no threats that we revoke probation.
Sure.
Excuse me.
Right, and to the state's other point of, well, we have these conditions of probation, and we need to make sure they're not violating them. That's a fair point, but there has to be some kind of limiting principle. The state didn't ask as a condition of probation that they're monitoring all conversations of any of these defendants who have pleaded, and I suppose there's a heightened risk, if you will, when you're dealing with a co-counsel, but I think there always has to be some level of professionalism and trust involved when we're dealing with officers of the court. So let me ask Mr. Stockton, is this something Mr. Giuliani was planning to be sitting right there in the room as you interviewed these people?
No, not at all, Judge. He unless there is an apartment in New York, he's not coming down here to interview or where these people reside at the time. Judge, and I don't think I completely hit on this, but the main reason I filed this is in the colloquy, and when you were announcing your sentence, one of the things you said was, and this was just on defendant Jenna Ellis, she's not to have any contact either personally or through other agents.
Sure.
I don't think this is what the court meant, but at the same time, I can see somebody that's wanting to comply with the letter of this that might need some clarification from this court that it is okay for them to discuss this with not the defendants themselves, but with the defendants' representatives.
All right. Well, just again, anticipating that this may be a concern with other co-defendants as well, I think it's worth, I'll file a brief kind of order and response. Again, I think case law in the alternative, we can take a look at that. But essentially, a witness can't be compelled to have an interview. The witness gets to set the conditions. If they want the state there, I think the state gets to be there. If they don't want the state there, I think they get to speak with you privately, and they're pretty much the ones in control at that point. There weren't any other conditions as part of their sentencing that proved otherwise, right? All right. Is there anything else then we think we should clarify there or needs to be addressed?
No, Your Honor.
So then we move on to Mr. Giuliani's more substantive motion.
Respectfully, Judge, I think we can handle this even quicker.
Okay. I remain cautiously optimistic.
Judge, this was filed by Mayor Giuliani's prior counsel on September the 8th of 23. Shortly thereafter, they withdrew from the case. The court set down the motions hearings on pretty much everything except this one, so the state hadn't responded at that point. I filed a motion for a hearing on this, and very quickly the court set down this date, and the state has not had an opportunity to respond yet. In talking with the prosecution, Judge, what we've discussed, if it pleases the court, to begin with, a lot of this has already been taken care of in argument. You'd just be hearing redundancy. But there are three areas that I don't believe have been addressed, and all three of those areas deal with the overt acts that occurred in other states.
Sure.
And one of them had to do with equal protection, one of them had to do with Brady issues, and the other had to do with jurisdiction. In talking with the state, they were going to, if it pleases the court, no argument today, them present their side of it in writing to the court, and then maybe give me, if I need to respond, another 10 days or so to take care of that.
All All right, and then we just handle it through the briefing?
Yes, Judge.
All right. And just by way of kind of focusing in the briefing, Mr. Stockton, on the equal protection issue, just when I was kind of making a preliminary look through it, I want to make sure I understand the argument. It's that, is the concern simply other states could prosecute your client for the same predicate act?
Yes, Judge. And for instance, arguably Georgia, you can't be sentenced for the RICO and the predicate act, but in Florida you can. There's just
Sure.
Georgia.
But how does that become a double jeopardy issue if all the states are separate sovereigns? I mean, couldn't he be convicted in every single state, all 50 states, if there was an issue, without any double jeopardy concerns whatsoever?
You may have a point, Judge. I mean, there may be something to that, but.
All right, well, that's something to focus on in briefing then.
Thank you, Judge.
All right. Okay, then, we'll take that up on the papers. I guess since we are all here together still, I can open it up to general housekeeping for everyone who's still here and with us.
Certainly, Your Honor. Catherine Bernard here for Jeffrey Clark. And we had adopted President Trump's motion to compel, and it looks like the court has ruled on those issues at this point that the representations of the district attorney's office that they have not been given access to any classified or private information that is not publicly available, but that the court is willing to revisit that ruling should any additional information become available.
Sure.
Do you understand that correctly? And we did also, there has been quite a bit of communication back and forth via email between the district attorney's office. And so out of an abundance of caution, the district attorney's office had included some of our previous requests specifically for communication based on TUI regulations, whether or not TUI letters have been received for Mr. Rosen and Mr. Donahue. And so we did, out of an abundance of caution, flesh that out into a new motion to compel, simply filed on behalf of Mr. Clark. And we are prepared to take that up today, and I do have copies for the state, but of course, if the court would prefer to hear that at a separate time, we are available.
Right, so I think you filed that today. I was able to read it, but obviously we didn't notice it for today, so if the state's not ready to hear it, then I think we need to give them an opportunity to digest that and respond. But perhaps we could at least make sure we understand and we're focused on the issues at hand. Well, actually, first let me just ask the state if they want to take it up today in the spirit of efficiency.
Judge, we appreciate that, and the state, of course, willing to give us time, we will take all the time that the court's willing to give us.
Okay, how much time do you need?
I mean, we can hear whenever we set for the next, since we're talking about moving forward the next hearing date that the court said, I would just say maybe not next Friday, it seems very jam-packed, but maybe the next hearing after that.
All right. And Ms. Bernard, I just want to, again, to focus the issues. That motion, we're honing in on the actual communications between counsel and the committee or the White House, right? It's not so much what Mr. Sadow was getting at in his motion to compel about what other evidence, documentary or otherwise, came as a result. You're looking for the actual communications that have occurred between the two entities, right?
Yes, Your Honor, particularly if there is anything in response to the request for a TUI letter that we believe was made for both Mr. Rosen and Mr. Donahue. It has been reported. We included as an exhibit to our filing some of the media reporting that indicated that that request had been rejected, and we do believe that that would be material and relevant to Mr. Clark's defense.
As a defense of?
And Your Honor, at this point, we believe that it would be material and relevant, particularly if Mr. Rosen and Mr. Donahue, who are the main witnesses who we believe they are prepared to provide evidence against Mr. Clark. That is the case with his ongoing proceedings within the District of Columbia. And so we believe that if they are not going to be available as witnesses, that will be a tremendously important element of the case going forward.
Right. So if an investigator is out there trying to put a subpoena in a witness's hands and they just can't find them, is that something that you also think falls under Brady?
Potentially, yes. I don't know that that would be the analogous situation here, since it does involve intragovernmental communications, particularly with the individuals who potentially are responsible for initially leaking the draft letter that was in late January of 2021.
So again, we're looking for the information. We're looking for at least a response from the district attorney's office as to whether or not they received anything back from the Department of Justice in response to that request.
Right. So I'll just give you my initial reaction as a preview to, as the state gets its response in the hearing, is that I think the first aspect of it, it seemed you were raising concerns or kind of building an argument about selective prosecution, right? And that has more of a legal hook, if you will. But the latter half of it was talking more about, just to boil it down, hey, we need a heads up of who could actually be able to walk through the courtroom and present evidence. That was a kind of a more novel theory to me. So if you've got something else that kind of connects those dots, I'd be welcome to hear it. But that by itself seemed like a bit of a stretch. So we'll take it up at the hearing and open the floor back up. I don't know who is still with us at this point, or if there's anything else to address, or if it's kind of petered out, or where we are. But anything else? Okay, then we will stand adjourned, and we'll see you next Friday.
Thank you, Your Honor.
Thank you, Your Honor.
Sure thing. Bring them on. It's the launched 1,000 PowerPoints.